Hello, good evening. We are live. We are live, waiting for people to get in. We are live. I see two people. Hello. In the comment, please say hi in the comment. Who's in? Please say hi in the comment so we can get started. Say hi in the comment. We are going to be talking about prosecutorial discretion. And what it really means and how anybody can benefit from it. If the person is in removal proceedings or they have an order of removal, or even if the case has been closed a long time ago, but you have another type of relief, you want to file for it, we are going to really talk about it in details. Say hi in the comment. Who's there? Say hi in the comment. Hello, Modesta Danson. Yes. Yeah, we are going to be talking about prosecutorial discretion. Okay. The power of the government to drop a case, dismiss it, close it, and remove you from removal proceedings. And how this one is really good because it's giving a lot of power to attorneys from the government, really how to use it. We are going to get into it in details. Let me share the screen with you. I'm going to do some explaining first, then I'll take questions. Okay. Hello, Ara. I'm gonna do some explanation first. Okay. I'll come back 10 minutes or 5 minutes explanation. Come back and do questions. Hi. Okay, let's get into it. I'm gonna share the screen with you. Share the screen so we can talk about it. Okay, so this is what we have, right? April 3rd, 2022, prosecutorial discretion, new memo. They have divided cases in two categories. Okay, we have priority cases and non-priority cases. When it comes to priority cases, okay, they have priority A, threat to national security. They have priority B, threat to public safety. And they have priority C, threat to border security. Okay. And they have non-priority cases where the person does not have any criminal record and they don't have any other inadmissibility issues except for unlawful presence, of course, depending on how you enter the US. Okay, so when it comes to threat to national security, when it comes to threat to national security, we are going to be talking about how this is going to play out. Okay, if a citizen has been charged for terrorist related activity, espionage related activities, uh, terrorist activity, or and engage in terrorist activity as defined in this section of the law, right? So those people are called priority A, and they are a threat to national security. And if we have priority B, a threat to public safety, that includes people with serious criminal record, okay? A really serious criminal record. That's when you're a threat to public safety. But this is where the good news is, okay? The good news is that you can mitigate those factors, okay? There are some aggravating factor and there are some mitigating factors. If there are a lot of aggravating factor, then the ICE is just gonna deny your prosecutorial discretion request. Those are the aggravating factor. It's basically the gravity of the offense, of conviction and the length, the nature of the sentence imposed, the nature and the degree of harm caused to the victim or to the community. the sophistication of the criminal offense, use of threatened use of firearm or dangerous weapon, and sectary, etc. Right? But mitigating factor, that's where they look at lengthy presence in the United States, a mental condition that may have contributed to the person committing that crime, physical or mental condition requiring care or treatment, status as a victim of the crime, witness or party in legal proceedings, okay? And the impact of removal on the family in the United States. Then we have, and then it goes beyond that. If you are a provider, a caregiver, provider, or caretaker, something around those lines, you can benefit from mitigating factor. Then we have threat to border security. That's priority C. Okay, priority C. This includes people like you have, for example, serious immigration benefit fraud. That may include fraud that has been criminally prosecuted, okay, including knowingly entry into marriage for purposes of evading any immigration law. That's like fraudulent marriages, sham marriages, forging, counterfeiting, altering false documentation, frivolous asylum case, serious type of fraud. For example, falsely claiming U.S. citizenship, a lot of fraud that you are under. If you have those type of charges, then you are under priority C, border security. Then we have non-priority people here, right? And then they can exercise prosecutorial discretion. So if you are into a priority case, we have to look at mitigating factors and determine whether the ICE is going to collaborate with those factors, and maybe they can drop your case so you can adjust status, okay? So, but non-priority cases, if you're not among those people we just cited, then you can have another form of alternative. They can drop your case, continue the case, ask for dismissal of proceedings, notices to appear, dismissal of proceedings, administrative closure of the case, stipulation of issues and relief, continuance, pursuing appeal, joining motion to reopen, etc., etc. Okay, so I'm gonna stop sharing. I'm back here trying to explain it. Where's the comment? I need to see the comment. Okay, so trying to explain it in simpler terms is this, okay? If somebody is in removal proceedings or they have an order of deportation or removal, or the case was closed, administratively closed, and now they find themselves that they have another petition or they can benefit from a subsequent petition from a family member or employment, but because of whatever reason they have closed their case or removed them, they cannot adjust status. Now USCIS is telling us that if you are under those low priority, you can join the motion to reopen your case, dismiss those removal proceedings, and then adjust status, provided that you have that way to adjust status, okay? But if that person is high priority, then we can look at mitigating factors and see if ICE will be willing to dismiss the case. That becomes like you have to fit some type of exceptions. But this is a great opportunity because they're trying to reduce backlog. efficiency too for the court and use their resources to do something else instead of just prosecuting people in immigration court. Because remember, we have like 1.5 million of cases in removal. So I'm gonna be taking questions here. Yeah, taking questions. Taking questions. Hello, Denise Forbes. Who has questions? Looks like nobody has questions. If you have a question, please type it. Hello, ready. If you have a question, please type it in the comment so that we can answer those questions. Type it in the comment so we can answer the questions. If there is no question, then I'm just gonna end this live session, because some of you guys have been asking about, oh, when are you gonna do live? When are you gonna be live? When are you gonna be live? And now that we are live, nobody's willing to ask questions. Then if there's no question, I am just gonna go ahead and check. If you are in removal proceedings and you have a case pending with USCIS, or you have a petition that you're trying to file with USCIS, then yes, you can go back and ask them for prosecutorial discretion, depending on which category you fit into. Hi, Musa. Hi, Abdullah. Hi. Questions? I'm taking questions. So if you have questions, please put it in the comments so we can answer those questions. Yeah, I'll be taking questions. If you don't, you need to start liking the video too as well at the same time. Please like Ready, Forbes, Ara, Back. Please like, please like. You have a DACA, Sabu, you have a DACA and you are in removal proceedings, you need to ask them to close that removal proceedings. Administrative closure. You need to ask for prosecutorial discretion so they can close your removal proceeding case because you have DACA. That's what I'm saying, Sheikh. You need to use this opportunity because this memo is there. You know, those people, they change things all the time. So when the memo is still valid, that's when you file for prosecutorial discretion so they can terminate your removal proceeding case depending on what you were charged for in that case. Oh, Modi Musa. I don't know about that because remember last year we've been talking about this bill, and now they're talking about a bipartisan bill that's going to be presented in November. So I don't know much about it because I'm not following it. I just want to see it to a completion before I come here. I have to see something tangible before I start talking about the bill, because last year all of us were in a roller coaster emotional journey. So we don't want to go through that like that anymore. We're going to wait for them. They bring something tangible, passes the House, passes the Senate, something tangible. That's when I'll be talking about it. It has to be so tangible for me to be talking about it. But there's something going on. They're talking about a bipartisan bill by November. Okay, Musa. Ready. I have filed asylum withholding of removal. So you file asylum, and what is the question? Back, you're welcome. Yeah, hierarchy. You need to ask for prosecutorial discretion because right now they are trying to help to cancel those removal cases. Okay, that's the good moment to ask for them to terminate your removal proceedings so you can try to find a way to adjust status, maybe to employer, to your job. So you need to ask them that. Ready, what is the question? You are in removal, but what is the question? I don't see the question. Yeah, I'm taking question. Please put your question in the comments so we can answer those questions. Again, as a reminder, we are talking about prosecutorial discretion, the power of the government to drop the case, terminate removal proceedings. They are trying to do it, especially for people with no criminal records. They're trying to terminate those removal proceedings so that those people, if they have something else available for them, they can adjust status outside of the court, outside of immigration court. This one is even better, even if somebody has some criminal record. They're trying to see if they can mitigate with some other factors and try to alleviate or really lift the burden. So this is a good time to apply for prosecutorial discretion, because things can change anytime with this immigration. Okay, please like my video, please share, please comment, keep commenting. And if you need a consultation about your prosecutorial discretion case, please call me 202-751-2180. Email is always on display. Consultation fees apply as usual. So we can assess your case and see if it's going to be so. Yep, I've answered all those questions. Anybody else who else has a question? Please put a question in the comment. I think I've answered all questions. Please put a question in the comment. Yeah, if there's no more question, we are going to end this live. Maxine Dennis, can someone adjust via sister? Yes, sibling petition, you can, but this is the petition that takes up to 16 years because the visa is not available immediately. You might have a I-130 petition approval or approved, but you cannot adjust status until the visa becomes available, which takes forever. It can take up to 16 years. You're welcome, Dennis Maxine Dennis, you're welcome. So any question, taking questions? Yeah, some people have been talking about I'm not doing live sessions anymore. And today we decided to take some questions. And we are talking about prosecutorial discretion, the power of the government to drop a case, terminate removal proceedings on their own discretion. This is the best time to ask for it if you qualify. It's really going to allow you, if you have another thing else, to adjust status. Sanita Dasparia, no, that it does not apply to pending asylum interview. This applies to people who are in removal proceedings with immigration court. Yeah, people with cases at the immigration court. Back after your removal gets lifted, you'll be able to travel with DACA. You have to apply for advanced parole, and if you get approved, then you can travel. But yes, you have to terminate the proceedings first, because if you're in removal, you cannot travel no matter what, because you stay outside of the country if you try it. So you have to terminate your case first back. then apply for advance parole, and once you get approved, then you can travel. That's how you're gonna have to do it. Sanita said, thank you. You're welcome, Sanita. Please like, share with your friends so they can subscribe to my channel. You need to be sharing my videos because we're stuck at 10,000. We're supposed to be getting at 11 subscribers a long time ago. It's like you guys are sleeping on it. Like, really, you need to be sharing. You're welcome. You're welcome. You need to be sharing back. You need to be sharing my videos with your friends so they can like and subscribe. Okay? Thank you. So I'm taking questions again. I'm taking questions. Anybody has additional question? Thanks, back. Anybody else has additional question? If not, then we are going to end this live session. We did it for 21 minutes. Oh, BB Nelly. I'm doing great. Thank you. Well, I've been busy with those cases. You know, I'm a solo practitioner. I work on my own. So, yeah, sometimes it gets a little crazy with cases. So, we have to slow down with those videos. When we get time, we come back. That's just how it goes in this profession. But thank you. I'm happy that you came. Please like, share. Thank you that you came. Do you have a question, BB Nelly? Yeah, somebody was asking me about. Sometimes people ask questions that maybe next time I'll bring those questions to a live session. People are asking about, well, asylum cases are pending. What can I do? It has been a long time. What you can ask for expedited requests and see if it's gonna help. You just Google USCIS expedited request and try it. It doesn't cost you anything. You call them, you give your reasons and see. For asylum cases, my friend, they are not doing anything. The only thing they said, they're trying to reduce backlog by hiring more workers and stuff like that. But I haven't seen any movement yet. Already you are non-priority category. Yes, you should ask for prosecutorial discretion. Yep, you should do that because this is the best time, because you don't know if you go there to court, if you don't have any tangible, like let's say you don't have any good defense, then you might get deported. So okay, I think, thanks. Let me put it here. So we are going to terminate on this live session. We're going to end it. So asylum case pending, nothing is moving so far. I haven't heard anything so far. But what they're saying, that they're trying to start moving cases a little bit faster, especially with employment authorization card. They said they're really going to try, and they are going to implement premium processing as well. We're waiting for that rule to be published in the federal notice, register federal notice, so that it can be effective. It takes at least 45 days. So since they said it, yeah, we have to wait a little bit. Probably by May sometime, they might open that premium processing, and people will have the opportunity to pay USCIS additional fees so that their case can move a little bit faster. you can visit the USCIS to know what type of cases or applications that will be open for premium processing. I've talked about it before as well. Yes, they're really trying to reduce this backlog. They're doing a lot of effort. As far as immigration bill is concerned, they are talking about a bipartisan bill by November. And let's just wait and see, because we don't want to get into that emotional roller coaster like last year. No, 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 we're not doing it. Please share, like, subscribe. If you need a consultation with me, please do not hesitate to call me. Consultation fees apply. As usual, have a great evening. Good night. Thanks. Bye-bye.